Hello, and thank you for joining us for today's session, Trademark Basics. My name is Daniel Anzueto, and I'm grateful to welcome you to today's session. If this is your first time attending one of our workshops, let me provide some context on Startout. Startout accelerates the growth of the LGBT community to drive our economic empowerment, building a world where every LGBTQ plus entrepreneur has equal access to lead, succeed, and shape the workforce of the future. I'm excited to introduce our host for today's session, Kyle Ingram. Kyle is an attorney in the Trademarks Customer Outreach Office within the United States Patent and Trademark Office. Prior to this, Kyle worked as a trademark examining attorney for 6 years. As an attorney, Kyle has previously worked for the U.S. Department of Agriculture and the U.S. Department of Justice. Before attending law school, Kyle served in the U.S. Air Force as a contracting officer. Kyle obtained his Juris Doctorate from the University of Oregon, his master's degree in natural resource management from Virginia Tech, and his BA in economics from the University of Virginia. Kyle, thanks so much for being with us today. The floor is yours.
Yeah, well, thank you for having me. So just want to make clear, we are sharing the PowerPoint presentation right now, correct?
Correct.
Excellent. So thank you for that introduction. So today's presentation is going to be Trademark Basics, what every small business should know now and not later. We'll go over some trademark fundamentals, kind of what a trademark even is. We'll move on to the benefits of a federal registration. We'll discuss some of the issues you should consider when selecting the trademark you'd like to federally register. We'll briefly go through the filing and registration process. There's a lot there, so we're going to do a kind of a high-level overview of it. And then we'll end with some of the resources you can access as you go through the process of applying for and hopefully registering your trademark. So let's start off with the fundamentals. I give this presentation fairly frequently, and when I give the presentation, I encounter a pretty broad spectrum of experience when it comes to trademarks. I'll talk to some folks who say, listen, Kyle, I've already registered 10 trademarks. I don't really need a lot of help with it. And I'll say, great, keep on keeping on. And then on the other end of the spectrum, I'll encounter folks who say, look, I've just started up this business. I know the word trademark, I've heard it before, but what is that? And even if you're at that latter end of the spectrum, I'll bet you're more familiar with trademarks than you think. Up on the screen now are a variety of fairly popular modern trademarks. And when you see these trademarks, I'm betting you immediately associate them with specific goods and services. For example, that apple in the upper left-hand corner, you see that and you think smartphones, you think computers, you think electronic peripherals, you might think streaming services. Coca-Cola in the upper center, you think soft drinks. The golden arches there in the upper right, you think fast food restaurants. Amazon, you think the online marketplace services for anything and everything you want to buy. Maybe web hosting services, so on and so forth. The point here is that these recognizable trademarks are immediately associated with specific goods and services. But what does the trademark do? What is it? So a trademark is anything that identifies the source of goods and services and distinguishes them from the goods and services of another party. So think about when you go out to eat. You and your friends, you go to the table, you sit down, the server comes by and asks, what would you like to drink? And you say, I'd like a Coke. The server says, sorry, we don't have Coke. Is Pepsi okay? Right there is trademarks in action, Coke and Pepsi. Both of those are terms that identify the source of the goods and services. You see Coke on an aluminum can or on a spigot at a soda fountain. You know what that is and where it came from, who made it. Similarly, you see Pepsi on the side of the can, on the spigot at the soda fountain. You know what that is and where it came from. And you know that a Coke isn't a Pepsi isn't a Coke, and you know what's in those goods. You know what they taste like. You know the character of those particular soft drinks. So think of your trademark as providing legal protection for your brand. how it is you identify to consumers that whatever it is they're seeing on the shelf or whatever services are being provided came from you and not someone else. Before we go too deep into what a trademark does, let's briefly discuss what a trademark does not do. So, a trademark doesn't mean that you legally own a word or phrase. It doesn't mean that you can stop other people from saying that word or phrase. It doesn't mean that people owe you money if they say that word or phrase. What a trademark is it's an exclusive right to use a particular word or phrase as a source indicator for particular goods and services. So let's think about Apple, right? Apple Incorporated owns a federal registration for the term Apple for smartphones, computers, electronic peripherals. Does that mean that they own the word Apple? No. So we can talk about apples all day. We can start a business that sells apples, apple pies, apple cakes. We could advertise apple bottom jeans. We could give nutrition and exercise tips to people with apple shaped bodies as opposed to pear shaped bodies. We can say an apple a day keeps the doctor away, so on and so forth. Apple, 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 and it's not a problem. Apple Incorporated can't do anything about it because they are protected in the exclusive right to use Apple as the source indicator for those goods and services. They don't own the word Apple. Now let's look at another situation. Let's say that I invent the next greatest smartphone. Everything that today's smartphones can do, mine can do better. It's huge, but it can fold up 15 times to fit into your pocket with no phone outline in that pocket. So my stylish clothes can keep on looking stylish. And I want to call that phone an Apple phone. Is that going to be a problem? You bet your sweet apple it is. And because I am using Apple as the source indicator for goods and services that Apple Incorporated is using Apple as a source indicator for, that's going to be a no-go. Now, later on in this presentation, we'll talk about when a particular trademark usage is too close to something that's already registered. But for now, just keep that Apple example in mind. Now, technically, if we're going to get specific with our terminology, a trademark indicates the source of goods or products. If you are using the word or phrase or logo to indicate the source of services, it's called a service mark. Now, don't worry, you can use the word trademark interchangeably to refer to both. We actually kind of do it a lot, even here at the agency. You're not going to be penalized for it. There's no legal consequence for using the wrong term. We just like to let people know, just in case they apply for a service mark thinking, I've got a trademark coming. And then they start to see service mark in those correspondence with the office. It's not going to throw them off. It's not going to throw you off. You know the difference now. But you can use trademark interchangeably. So let's talk about the common source identifiers. We've got brand names, slogans, and logos. And these are the three most common types of trademark that we see. Now, a lot of companies, right out of the gate, for their brand name, they will try to register their company name. And that's fine. You can do that. You can register your business name as your brand name. Other businesses choose something a little flashier. So if I am Kyle Co. Products Incorporated is my business name that I've registered with the Secretary of State, well, there's not a lot of spice to that. You know, maybe I don't want that to be my presence out there in the market. That's not how I want folks to think of my goods. Maybe I want something sexier and flashier. And if that's the case, well, I'd register something different. But don't feel bad. You can register your business name. You can register whatever it is you want as your brand name. With Coca-Cola as the example, Coca-Cola is the brand name. It's the real thing is one of many slogans that they have registered with our office. And over here, we see two logos that they've registered. You have the composite mark that has design elements and wording on it with that always Coca-Cola seal. And then you have just the design element with the silhouette of that bottle. Now, you recall I said that a trademark is anything that functions as a source identifier for goods and services. So we have a lot of non-traditional types of marks. You're probably familiar with some. You got sound. Think of the NBC chimes. Dun, dun, dun. I'm a little tone deaf, so you'll have to use your imagination. There's a reason I went into law and not entertainment. We have color. So if you're sitting in your living room and you see a dark brown package delivery van drive by, I'm betting you know what company that is, even if you didn't see the logo. And that's because UPS has a federally registered trademark for the color brown as it relates to package delivery services. Scent and smell, those of you with kids or who remember your childhood well might remember the smell of Play-Doh. That smell is a federally registered trademark. So if you're working with modeling clay and you're smelling that, you know that it's Play-Doh brand modeling clay from Hasbro and not some other type of modeling clay. You have motion. If you're in a movie theater, you're waiting to watch a movie, and a little clip comes on where a desk lamp hops across the screen and sees one of the letters in a particular word and bounces on that letter until it's smashed down. Well, you are looking at a registered mark for motion. Pixar has a federal registration for that particular animation as it relates to films. Holograms, like the holograms on Upper Deck sports cards, and then configuration and shape. That little bottle there in the bottom right, if you see that on a grocery store shelf, you probably don't need to see the label to know that that is a bottle of Coca-Cola. Now we're going to move on to the knowledge checks. These work a little bit better in person. So here in the webinar format, I'm just going to read the question and then give you the answer. Question one, does a federally registered trademark mean that you own a word or phrase? No, it does not. What that means is that you have the exclusive right to use that word or phrase as a source indicator, as a brand for your particular goods and services. Do you have to use your business name as your trademark? Again, no, you do not. A lot of businesses do, especially small businesses that are just getting started, but don't feel constrained by that. If you think there's something out there that has a better commercial impression, a little more flash than your business name, by all means, register that instead. Or register both if you'd like. There's no limit to the number of federal registrations you can have. So let's talk about the benefits of a federal registration, why you'd want to federally register your mark in the first place. One of the questions I get fairly frequently is, Kyle, look, I have this small business. I think it's fine at the scale that it's running. I'm not looking to grow the business. Do I really have to federally register my trademark in order to have trademark rights? And I say, no, you do not have to federally register your trademark in order to have rights in that trademark. And if you choose not to register your trademark, you're going to be protected by common law. As we'll see here in a minute, common law doesn't give you quite as broad a scope of protection as a federal registration would give you, but in some circumstances, it might be a better fit for your business. Again, I can't tell you which one that is. That's sort of a legal determination, a business decision that you'll have to come to on your own, but I'm going to help inform that decision. So your common law rights, these are created as soon as you start using that trademark in commerce. You don't have to check in with anyone. You don't have to apply for anything. You don't have to file anything with any agency. They are created as soon as you start using that trademark. Real easy to create common law rights. However, you are going to be limited to the geographic area where your mark is actually used. Now, that's in contrast to a federal registration and the rights that it gives you, where you have a presumption of ownership in all 50 states and US territories. So you can already see where your protection's a lot more broad with that federal registration. Now, the symbols that you use if you're relying on common law to protect your trademark are the TM and the SM, and that stands for trademark and service mark, respectively. Now, again, if what you have is a service mark and you use a TM instead, that's not going to affect your rights. That's the difference between trademark and service mark. Trademark for goods, service mark for services. You would never use the R with a circle in it because that indicates a federal registration. So let's talk federal registration. These are created when you federally register your trademark, obviously. It creates a legal presumption that you own the trademark and that you have a right to use that trademark in all 50 states and US territories. It also puts the public on notice of your rights in the trademark because when you apply for that trademark, it goes into our database where all applied for marks and registered marks appear. So if you have applied for your mark and you're out in California, and I'm way up in Maine, and I want to federally register a mark that's identical to yours, one of the first things I would do is hop in that USPTO database, search for that mark, and what I would see is that you have already filed an application. And so that would tell me, okay, they beat me to the punch here. Maybe I should back off of this, as opposed to common law rights where there isn't this database anywhere where all the applications are aggregated, where people can just look. It's a one-stop shop for federal rights and figure out if someone has superior rights. You can bring legal action regarding your trademark in federal court. And that's good because these courts tend to have a deeper subject matter expertise as it relates to intellectual property. With state courts, you may not get that same consistency of rulings that you would get with federal court. You also can record your registration with Customs and Border Protection. And what that does is if there are counterfeit goods coming into the country with your trademark on it, if you've recorded your registration, Customs and Border Protection can immediately seize those counterfeit goods, cuts through a lot of red tape and other administrative processes that might otherwise hold that process up. Now, maybe you're not at a point now where you're worried about counterfeit goods, but I like to tell people in today's world with social media being as pervasive as it is, all it takes is for your stuff to show up on a couple of social media accounts and suddenly you're blowing up overnight and you have a 20,000% increase in demand for your goods. And if you think that counterfeiters overseas aren't paying attention to the latest trends on social media, ooh, you'd be wrong. So if you have this federal registration, you can get that stuff in place a lot more quickly. And you can use the federal registration as a basis for filing in another country. There's no such thing as an international trademark. There's no trademark that you can get, no registration you can get that's just going to protect you in every single country on the planet. You have to apply to all of those jurisdictions individually in order to be protected in those countries, in those jurisdictions. But if you have this US federal registration, that can speed up the process a lot of times. Now, once you get that federal registration, you no longer have to use that TM or that SM, unless, of course, maybe you have some sentimental attachment to them. I don't presume to know how you feel about your TM and SM marks. But once you get that federal registration, you do get to use that R with a circle in it. And that puts everyone on notice that you have a federal registration. Knowledge check time. Are you required to register your trademark with the USPTO? No, you are not. If you do not register your mark with the USPTO, you're going to be relying on common law rights, which, as we saw, the scope of that protection is not quite as broad. Does registering your trademark with USPTO give you international protection? No, it does not. However, that federal registration can expedite the process of getting registrations in other countries. So let's talk about selecting a trademark. The mission of the USPTO is to register any trademark that is eligible for registration. If it can be registered, we're going to register it. But keep in mind, not every trademark is registrable. There are a set of statutes and regulations that every application and mark has to comply with. And if a particular application or mark does not comply with those, unfortunately, we're not able to register it. And not every trademark is enforceable. We don't really have a lot of time to go into the nuance of common law rights versus federal registration rights, but in the United States, the first user of a trademark is going to have superior rights. Now, keep in mind, if that first user is common law, their rights are going to be limited to that area where they're actually using the mark. And if a later user gets a federal registration, they're going to end up with superior rights in all the areas where that common law user was not actually yet using the mark. So enforceability is your ability to take your federal registration, hold it up and say, hey, you, stop using that mark. It infringes on my rights. If there's someone else out there with superior rights, that's not going to be an enforceable trademark. We don't talk too much about enforceability because we at the USPTO don't deal in enforceability. That's something that you as the trademark owner are going to have to police. So there are two main concepts we're going to discuss today as it relates to registrability: the likelihood of confusion refusal and the descriptiveness refusal. So let's talk likelihood of confusion first. The idea behind a likelihood of confusion refusal is that we at the USPTO don't want to register marks that would confuse consumers about the source of goods and services. So what do we mean by that? There's a two-pronged test. And for that, we look at, are the trademarks themselves confusingly similar? Do they sound similar? Do they look similar? Do they have a similar commercial impression? And you notice I said similar and not identical. The test is not identical. So the marks don't have to be exactly the same for this prong to be met. The second prong is, are the goods and services related? Relatedness is going to be a very evidence-based analysis. So what you do is you take the goods and services of the registrant, the goods and services of the applicant, and you say, okay, are there entities out there that make this stuff and this stuff under the same mark, under the same brand name? And if they do, then those goods and services are related. So if you have an application out there where the trademark itself is similar, confusingly similar to what's already registered, and those goods and services are related, then you're going to have a likelihood of confusion. That is, we think that if we registered this mark and gave this person the exclusive right to use this mark in connection with those goods and services, it would confuse consumers. Consumers would see this mark and this mark on these goods and services, and they wouldn't be sure which one was coming from where. Now, keep in mind, both prongs have to be met in order for this to be a likelihood of confusion. It's not enough for trademarks to be confusingly similar. And we're all familiar with identical trademarks that exist happily out there in the market. Think Dove. You've got Dove for chocolate and ice cream. You've got Dove for soap and shampoo. If you go through this test, well, yes, those trademarks are confusingly similar. They are, in fact, identical. But are those goods and services related? Do you see a lot of companies out there that do chocolate and ice cream and soap and shampoo under the same brand name? You don't. And because of that, Dove and Dove can coexist out there in the market. So when you're out there and you're doing your search to see if there's anyone else out there that has a trademark registration that's going to be confusingly similar with yours, don't despair just because you find one where the trademark is very close to what you want. You still have to drop down and do that second prong of the analysis. So I'm going to run through a few of them real quick just to sort of show how this works. Let's say you want to register T Marky for shirts. When you do your search in our system, you find T Marky for pants. So let's do that likelihood of confusion analysis, see if this is going to be a problem. T Marky versus T Marky, are these confusingly similar? Well, again, these are identical, which is the highest level of similar. So that first prong is going to be met. Let's drop down to that second prong, shirts versus pants. Are these related goods? Are there companies out there that make shirts and pants under that same brand name? Well, I am one of the least stylish people you will ever meet, and even I could probably name 20 different companies that make shirts and pants under the same brand name. So yes, that second prong is going to be met. And because the first prong and second prong have been met, this is a likelihood of confusion. Let's go to the second example. You're still looking to register T Marky for shirts, and you find T Marky for pants. Is this a likelihood of confusion? Let's run through the test. First prong, T Marky versus T Marky. Are these confusingly similar? Well, do they look similar? Not really. Do they sound similar? Uh-oh, we have a problem. So these sound either identical or very, very close. And because of that, these would be confusingly similar marks. As we discussed in that last example, shirts and pants are related goods. So this would be a likelihood of confusion. Let's do one more. You still want T Marky for shirts, and now you find T Marky for golf flags. Is this a likelihood of confusion? Well, as we discussed in the last example, T Marky versus T Marky, they sound either identical or highly similar, so that first prong will be met. Shirts versus golf flags. Are there companies out there that do shirts and golf flags under that same brand name? I'll be honest, I don't know. This is a great example of where you would need to go out and do that market research to see if these are related goods. If it were me, I would probably start out with um, companies that make golf flags. There's probably fewer of those, so it's easier to get a list of those together and then look at each of those companies to see, okay, do they also make shirts? Maybe I would start with like a golf related companies, Champion, Ping, Titleist, that sort of thing, if I were doing the search. But ultimately, this is one you'd want to go get more evidence on. So if you're going to do the search on your own, we of course recommend that you search the USPTO database. And that's going to have all of the federally applied for and registered trademarks. We also recommend you look on the internet. And this is a good way to get out there and find those common law right holders that may or may not have a superior claim to yours. And that'll also help you get an idea of the scope of their protection. Where are they actually using this mark? Then you can figure out, okay, is this something I want to proceed with, or is this going to be a problem? If you're in Texas and you find someone up in Rhode Island who's only using that mark in Rhode Island, well, maybe that's okay. Maybe you're fine having the rest of the country except for Rhode Island. But if you're in Austin, Texas, and you do a search and you find a common law rights holder in Dallas, Texas, well, that's probably going to be an issue. So definitely check the internet and just see if you can find those common law users that may or may not present a problem. Now, we do recommend hiring a private trademark attorney for this. Um, Obviously, that's not always an option, especially for businesses that are just getting started up. Attorneys can be expensive. Not me, I'm a government attorney. I'm as cheap as they come. But those private sector attorneys can be a little expensive. And it's understandable that businesses that are just getting started up maybe don't have the budget allocated for legal services right off the bat. We'll talk at the very end of the presentation about some of the places you can go to look for pro bono services, legal services provided for free by a lot of universities. But that private trademark attorney, should you decide to hire one, will give you a lot of bang for your buck. They'll be able to do that comprehensive clearance search of our database. They'll be a lot more familiar with the database itself, how to use it, how to use that search language. They'll have a better idea of what is and is not a problem as it relates to a likelihood of confusion. They'll also have more familiarity with state trademark databases, business name registries, foreign trademark databases, and they'll know a little bit better where to search on the internet to find maybe some of those hidden common law right users that could be a problem. And to close out our likelihood of confusion discussion, we're going to do a little knowledge check here. And this is an actual case that was decided at the TTAB, the Trademark Trial and Appeals Board. Someone wanted to register Exceed for agricultural seeds, and there was a registration for Exceed for live plants. Now we'll start with the easy one, the second prong. Agricultural seeds and live plants, those were related. There was plenty of evidence showing that those were related. And a lot of the argument, most of the argument, in fact, took place in the first prong as to whether or not Exceed is confusingly similar with Exceed. Ultimately, the TTAB decided that there was a likelihood of confusion here. Now, that said, I think there's a lot of room for argument here. You have in the registered trademark the mark exceed, which just means to go above and beyond expectations in terms of excellence. Here we're trying to register exceed. Sure, it sounds similar to exceed, but maybe there's a lot more going on with this mark. For example, it's not just the word exceed or a fanciful spelling of the word exceed. The breakdown of the mark is that you have the word seed, which directly describes the goods themselves, prefaced by the letter X. And in this particular instance, um, the letter X in popular culture indicates that something is revolutionary, it's mysterious, it's sexy, it's cutting edge. There's a definite commercial impression with the letter X. So when combined with this descriptive word, seed, what you're telling consumers is that the seeds you sell are revolutionary and sexy and mysterious and cutting edge and awesome. And that's a commercial impression that's pretty strong that isn't necessarily there with just the word exceed. So those are the types of arguments that an attorney would be making for you. And they would be relying on legal precedent and cases and statutes and all sorts of other stuff. This particular example I like to bring up because it highlights, one, the fact that whether or not there's a likelihood of confusion isn't always immediately clear. It also highlights the value that an experienced trademark attorney can bring to the application process. So in this instance, this one was refused for a likelihood of confusion. In my personal experience, I've seen cases where the marks were closer than this, and ultimately it was determined that there was no likelihood of confusion. So who knows? Let's move on to the merely descriptive refusal, the strength of the trademark. So the idea here is that we want to avoid using trademarks that fail to indicate the source of goods and services. The test is, does the trademark merely describe the goods and services, or something about the goods and services, or the customer base for the goods and services? For example, if you're in a home goods store and you see a bag of potpourri that says apple pie across the packaging, you're not going to look at that and go, oh boy, apple pie brand potpourri. I wonder what it smells like. No, you're going to look at that and that's going to tell you that potpourri smells like apple pie. And if we allowed that type of mark to register, one, you have words and phrases out there that aren't identifying a brand to consumers. It's not telling consumers specifically the source of those goods and services. The other consideration is, for example, with the potpourri example, if we were to grant a single person or a single business exclusive right to use the wording apple pie as a source indicator for their potpourri, well, you've kind of cut off all the other market participants who might also be making apple pie scented potpourri. And what about them? It's not really fair to tell them they can't use this descriptive wording for their goods and services that they would otherwise need to use. So, because of that, we tend not to register descriptive marks, except in rare circumstances, which we'll see here in just a minute. This is a nice little visual of weak marks to strong marks. The weakest marks you can describe, the weakest marks out there are generic. So generic terms are terms that can never be registered. They are the absolute weakest. Descriptive terms, they're a little better, typically not registerable, except in certain circumstances. Once you get to suggestive marks, now you're in the golden zone. These are strong marks. And the absolute strongest of marks are fanciful and arbitrary marks. So let's go through these. Generic terms. These are common everyday names for the goods and services. These will never be registerable. An example of that is milk, if the goods are dairy-based beverages. Milk is a common everyday name for dairy-based beverages. Accordingly, it's generic. So you can also think of specific types of those goods and services. So if the goods are sauces, you wouldn't be able to register uh, mustard or ketchup or chimichurri or barbecue because, again, those are common everyday names for those types of goods and services. Moving on to descriptive trademarks. So these directly describe something about the goods and services, and these are unregisterable on the principal register unless there's a showing of acquired distinctiveness. And what that acquired distinctiveness showing is, first of all, it typically requires a lot of evidence in order to show acquired distinctiveness. But what you are trying to show the USPTO is that despite the fact that this wording does kind of directly describe something about these goods and services, it has been used so continuously and exclusively in such a widespread way that consumers now view this wording as the brand, as the source indicator, and not just as descriptive wording for those goods and services. That's what's meant by acquired distinctiveness. So, scoop for ice cream is an example of that. Moving on to suggestive trademarks. Now, they sort of describe-ish an aspect of the goods and services, but not directly. It's more like they're suggesting a quality of the goods and services. And these are strong marks. These are registrable. An example of that is copper tone or suntan lotion. Now you'll notice the mark is not bronze colored skin. That would directly describe something about the goods and services. Rather, it's copper tone. It suggests the beautiful coppery tone that your skin will take on when you use these suntan lotion products. So that's the difference between a mark that's suggestive and one that is merely descriptive. So let's go on to the strongest category of mark, the fanciful and arbitrary marks. Fanciful trademarks are invented words with no meaning in any language. An example, Xerox for photocopiers, Kodak for film and cameras, Kleenex for facial tissue, Pepsi for soft drinks, Rolex for watches. All of these are made up words. Accordingly, there is no definition or meaning to them. So it's impossible for them to merely describe something. Finally, we have arbitrary trademarks. And these are actual words, but there's no association with the goods and services. These are registrable. For example, Apple for computers. Now, Apple is an actual word. And if those goods were um, cakes, pies, juices, fruit, well, then we're in that generic and descriptive territory, and that would be a very weak, probably not registrable mark. But because these goods are computers and apples don't really have anything to do with computers, they don't describe any aspect of the computer, it's an arbitrary mark and it's registrable. So let's move on to the knowledge check. So which of these would be registrable? Bicycle for bicycles or bicycle for playing cards? As you've probably guessed, bicycle for playing cards would be registrable as the arbitrary mark. Bicycle for bicycles would not be registrable as it is a generic term. Let's talk filing. Um, This is going to be a very high overview of the filing process. We're not going to get into the details of what gets submitted and what questions you have to answer, so on and so forth. But here's the general process. Your first step is applying for the mark. I like to say that there is step 0.5, and that's you doing the searching to make sure that there aren't any marks out there that have been federally registered or any marks relying on common law that are going to pose any issues with your mark. So that's step 0.5. Step 1, application. Once you apply, it goes to one of our examining attorneys. They do the legal analysis of your application and the mark and say, okay, yes, this is good to go. Sometimes, most times actually, there are little issues with the mark. That gets worked out between the examining attorney and you, the applicant. If you can work out all those issues and get that application in a condition to get approved, great. It moves on to publication. In some instances, it is not possible to overcome a refusal or a requirement. And in those instances, unfortunately, that application will abandon. And double unfortunately, you won't get the filing fee back for that. And that's not because we're jerks. It's because that filing fee is not what you pay in exchange for a registration. That filing fee pays for the upkeep of our IT systems. It pays for our administrative professionals who do the first round of evaluation of your application. It pays for the attorneys to do their legal analysis, so on and so forth. So that's what your fee is actually paying for. But assuming your application is in good shape and it goes on to publication, it's, apologies, it's made public for a period of 30 days. And that's when the public can step in and oppose registration. That's when a common law rights holder might step up and say, whoa, 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 no, no, no. I have superior rights in these states. You can't just let this mark register without any amendment to it. Typically, you don't have any opposition that happens. And assuming there is no opposition, you move on to the registration stage. Now you'll file using the Trademark Electronic Application System, or TEAS. You have TEAS Plus and TEAS Standard. And the total fee is determined by how many classes you include in the application. And if you're anything like me, you look at these numbers and you say, hey, I want to do the cheaper one. How do I do that? Well, it's simple. TEAS Plus is cheaper because you give us more information on the front end. When you go through the application process, there are questions that you need to make sure to answer. Some of them are if there's foreign wording, non-English wording in the mark, you need to provide a translation statement for that. If your mark is a name, image, or likeness of a living individual, there's additional stuff that you have to provide us with. But probably the biggest difference is with a TEAS Plus application, you have to select your goods and services from our ID manual. Now, don't worry, I know that sounds a little constricting. Our ID manual is huge, and a lot of the entries have blanks that you can fill in additional information. I was an examining attorney for 6.5 years. I examined, God, I don't know, 5,000, 6,000 applications. And in that time, I encountered exactly one business whose goods and services were not in our ID manual. So your stuff is probably in there. Definitely take a look first, see if you can get that T's plus cheaper filing option. If for whatever reason you don't comply with the T's plus requirements, all that happens is you get bumped back down to T's standard. So, you know, you don't have anything to lose by taking a crack at T's plus. So let's talk the application requirements. We need a clear drawing of the trademark, and I don't mean like get out your paints and your colored pencils and give us a hand drawing. All that we mean by drawing is an image of the actual mark itself that you would like to register. We need a listing of the goods and services, a filing basis for each good or service. That's just the legal grounds on which you're relying to file your application. If you're a US resident, typically it's one of two. You're either filing a 1A use in commerce, that's you saying, hey, I'm already using this stuff in commerce and that's why I'm allowed to apply, or a 1B intent to use, where you're saying, hey, I'm not using it yet in commerce, but I have a bona fide intent to, and that's what allows me to apply. You'll get to check that box in the application. We'll need contact information for the trademark owner, as well as a filing fee. We talked about the most common basis for refusal, the likelihood of confusion, the merely descriptive. There's geographically descriptive. You can sort of think of that as a subset of merely descriptive in the sense that the mark just describes where the goods come from or where particular ingredients come from. There's what's called the specimen. Um, that is when you show us that you're actually using your mark in commerce, you file what's called a specimen. And that's the proof that you're using your stuff in commerce. A lot of times applicants will file a specimen that does not comply with the requirements for a specimen, or it doesn't show use of their goods and services, and the trademark used in an ornamental manner. Now keep in mind that a trademark identifies the source of goods and services. If that trademark is used in a way that consumers would view it as just being decoration, it's not functioning as a trademark. So think like on the front of a shirt, really big, on the side of a coffee cup. Those are both places where decorative matter appears. Now, if instead of being really big on the front of the shirt, it is right here, like my cool guy USPTO logo over the right breast, if it's on the collar tag, if it's on a hang tag, well, that's where consumers are used to seeing source identifying matter. That's not going to be ornamental matter. For that coffee cup, think the bottom of the coffee cup, not really big on the side. Now, your responsibilities as a registrant, you have to enforce your own trademark rights. You can use your registration to support a cease and desist or sue an infringing user. Keep in mind, though, that once you have your registration, in order to maintain that potentially into perpetuity, you will have to file post-registration documents from time to time with the USPTO. Knowledge checks, and then we should be moving on to the resources and then ultimately questions. Are you guaranteed registration of your trademark? No, you are not. Like we said, every application and mark has to comply with statutes and regulations. If ultimately your mark or your application cannot comply with all of those, then it will not register. If your trademark registers, do you have to do anything to keep your registration alive? Yes, you do. You will have to file post-registration filings and pay additional fees, and that's going to come in between years 5 and 6, between years 9 and 10, and every 10 years after that. So now let's talk some of the resources that are available to you as you go through your application and hopefully registration journey. First and foremost, scams. Be on the lookout for scams. What I highly recommend before you hit submit on your application, check out this website. See what is going on with scams, what the latest scams are, the ways that scammers will often pretend to be us, pretend to be attorneys, um, get you scared about something that isn't actually a problem, and convince you to send them your hard-earned money. Unfortunately, we don't have any enforcement capability. We are not an enforcement agency, so we can't go clunk these guys on the head. All we can do is inform you as applicants of what you should be on the lookout for. You also want to be on the lookout for non-attorney filing firms. There's only two people who can represent you in your application process. That is you yourself, and that is a U.S. licensed attorney. If it is a non-attorney filing firm, they cannot represent you at the USPTO. Sometimes what some of the non-attorney filing firms will do is they will offer ultra low filing fees. They'll say, "Hey, we'll file your application for only 50 bucks." And you say, "Great, that sounds like an awesome deal." You pay them 50 bucks and all they do is fill out the application and send it back to you and say, "Great. Now all you have to do is pay the USPTO their fees." Ultimately, at the end of the day, they didn't really provide much of a service. They just kind of took the 50 bucks, gave you an application you could have filled out on your own and said, "Okay, now the fees are your responsibility." And again, that's not every filing firm, but it is a scam that we've seen pop up from time to time. Beware of misleading notices and offers. If it smells fishy, if it sounds too good to be true, it probably is. This is our website. There's a lot of great resources there. If you go there, hover over Trademarks tab. It's right there front and center. You'll have access to a lot of other great information and other resources. We have trademark videos. I don't think there are very many right now because we're rehauling or we're overhauling and revamping all of those videos to make sure that they are up to date with the latest and greatest in trademark developments. This resource is fantastic, the Trademark Basics Registration Toolkit. It goes over everything we've gone over today, except in far greater detail, and there are embedded links to other resources if you want to get more in depth. We also have the Trademark Basics Bootcamp. We are actually just finishing up this cycle of boot camp, but this is an 8-week program. There is one class every week. It's about an hour and 10 minutes of instruction and then 20 minutes of live Q&A. Bring your questions. You can get a little bit more in-depth instruction on trademarks than you've gotten here. We have the IP identifier. If you don't know what it is you have, you have a copyright. Is it a trade secret? Is it a patent? Is it a trademark? What's going on here? That's a fun little tool to run through and that'll show you. Free services and resources. This is what I alluded to earlier in the presentation in terms of pro bono legal services. If you go to this link, you can find a lot of law schools that have trademark clinics where a law student, under the close guidance of an actual practicing attorney or an intellectual property professor, will provide you with the legal services relating to your application. And they'll do that for free. Sometimes there can be a significant wait for those. As you might imagine, there's plenty of demand for free legal services, but certainly check it out. See if there's a school in your area that offers it. See what the wait is. Maybe it's perfect for you. We have the virtual assistant here. You can ask it some basic questions. It can give you some basic answers. Trademark Assistance Center. This is a fantastic resource if you have questions about the process of applications. If you have already applied and you are receiving correspondence and you don't know whether it's from us or from someone trying to scam you, this is a great place to reach out to. They can help you out. They cannot provide legal advice or business advice, though. Keep in mind, USPTO does not provide legal advice. That's true for the Trademark Assistance Center. That's true for me as well. We do not enforce legal rights. We cannot recommend specific private attorneys. And with that, I think we'll open it up to questions.
Fantastic, Kyle. Thank you so much. That was a very thorough and informative discussion on trademark basics. Much appreciated.
Well, thank you.
Three questions have come through so far. One of them, if I begin operating my online national brand relying on a common law trademark, can a competitor or nefarious actor federally register it?
So it's going to depend on the facts, and I can't really opine on legal hypotheticals. But what I can tell you is that if you're relying on common law, what you're going to have to show in any type of uh, intellectual property infringement case is you're going to have to show when you started using that mark. You're going to have to show the extent to which you were using that mark, the specific goods and services you were using that mark with, all of the places that you were using that mark. So you can see where that body of evidence that you're going to have to build in order to defend your case gets pretty voluminous. So I want to make another plug here for federally registering your mark, because if you federally register your mark and you have that federal registration, step one, instead of having to grab all of that evidence, you just hold up that federal registration and say, you see, I am the rightful owner of this mark, and it's incumbent on that other guy to show that you are not. So shifting that burden is huge in terms of legal proceedings. Um, it is difficult with online commerce to show like what is actual use. Um, but in that type of case, if you didn't have that total national use and you were only relying on common law, then ostensibly they could get that federal registration and kind of fill in the gaps where you haven't shown actual usage yet. And then they would have the superior rights to you in those places. So a federal registration can be a great defensive tool as well.
Fantastic, thank you. In the filing manual, can multiple goods and services be checked off within the manual?
Yes, absolutely. That is a fantastic question. So you can, when you apply, you can select as many goods and services or as few goods and services as you would like. I mean, provided you're actually using your trademark with those goods and services. Some folks have businesses that are multifaceted. And when they're coming in, they say, look, I just want one federal registration right now. I'm going to focus on my primary business, and then I'll handle the other businesses later on. So even though they do maybe three different things, if they do, I don't know, life coaching, clothing, and nutritional advice, maybe the nutritional advice is their primary business. So they can come in for an application and just do that. Or they can come in and select all three. So put as much or as little as you want in your application. Just keep in mind that the fee is going to be based on how many classes of goods and services there are. I don't think we really went into that. Your classes are just the categories of goods and services. There's 45 of them. So class 1 is industrial chemicals, class 14 is jewelry, class 25 is clothing, class 35 is business services, that type of thing. So if you come in and you sell clothing and you put 50 different clothing items in your ID, well, that's still just one instance of the fee, either the 250 for T's plus, 350 for T's standard. But if you come in and you do shirts and jewelry, well, that's going to be two instances of that fee because you have class 25 and class 14 in the application. Now, one quick note, that fee structure is going to change at the beginning of next year. So it's going to, the fees are going to go up, one, and two, the length of your identification may also incur additional fees. So I'm telling you what the fee structure is right now.
Fantastic, Kyle. Thank you so much again for your time. We're grateful for the support and partnership with the USPTO office. And we look forward to working with you all again in the new year. Thank you all so much for joining us for this session. We'll have the recording and the presentation sent out to all registered attendees in the next few days. Have a great rest of your day, all. Thank you.